Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut. And today, what I'm going to talk about are the automatic orders, which are in effect whenever there is a pending custody, legal separation, or divorce case. So I'll get right into it and share my screen to look so that we can look at the automatic orders together. So they are JDFM 158. That's the form number, and these are served by the plaintiff on the defendant whenever a, divorce or custody or legal separation case is initiated. So if we look at the top right section, this is an initial notice to the defendant. So in cases of dissolution or legal separation, if you or your attorney do not file a written appearance by 30 days after the return date, the plaintiff can ask the court to enter judgment against you for the relief requested in the complaint without further notice to you. So this blank, you just fill in the actual date, which is 30 days after the return date. In this event, judgment may enter against you as soon as 30 days after the return date if you were served with the complaint by personal service or abode service, so the paperwork being left at your house, or 60 days after the return date if you were served in any other manner. For example, you live out of state and were served through certified mail. So this is just giving a heads up to the defendant that, hey, if you were served with a divorce or a custody case or a divorce or legal separation case, you better file an appearance and tell the court, that you're getting involved in the case, because if you just ignore it, the plaintiff can finalize the case, without you ever appearing. So that's what that top section says. The following automatic orders shall apply to both parties, with service of the automatic orders to be made with service of process of a summons and complaint for dissolution of marriage or civil union, legal separation or annulment, along with a blank appearance form or an application for custody or visitation. So those are the forms that are to be served on the defendant whenever a case is initiated. An automatic order shall not apply if there is a prior contradictory order of a judicial authority. The automatic order shall be effective with regard to the plaintiff or the applicant upon the signing of the complaint or the application and with regard to the defendant or the respondent upon service, and shall remain in place during the pendency of the action unless terminated, modified, or amended by further order of a judicial authority upon motion of either of the parties. So, as soon as you sign the complaint, the automatic orders apply to the plaintiff. Obviously, at that point, they can't apply to the defendant because the defendant may not even know that a case is pending or that a case has been initiated. So they don't apply to the defendant until the defendant has been served with the paperwork. So in all cases involving a child or children, whether or not the parties are married or in a civil union, these numbers 1 through 6 apply. So these 6 sections apply to cases involving children. So the first one is neither party shall permanently remove the minor child or children from the state of Connecticut without written consent of the other or order of a judicial authority. So sometimes people take this to mean that, you can't leave the state with your kids when a case is pending. That is not the case. You just can't permanently leave. So you can't move to another state when a, divorce or custody case has been initiated, a divorce that involves children, obviously. Well, you can move, you just can't move with the children. 2, a party vacating the family residence shall notify the other party or the other party's attorney in writing within 48 hours of such move of an address where the relocated party can receive communication. This provision shall not apply if and to the extent there is a prior contradictory order of a judicial authority. So, if you're living together when a divorce or custody case is initiated and you have children and you move, you just have to give the other party a heads up as to where you are moving. 3, if the parents of minor children live apart during this proceeding, they shall assist their children in having contact with both parties, which is consistent with the habits of the family, personally, by telephone, and in writing. This provision shall not apply if and to the extent there's a prior contradictory order of a judicial authority. So what this is saying is, you have to encourage the relationship between your children and the other party, as has been customary in your family. So you can't just, if a divorce case has been initiated, you can't just move out, take the kids with you and have them not talk to the other party. That would be a violation of the automatic orders. You have to let the other party see your kids if that's, if they've historically seen them. Obviously, if your kids have not had any contact with the other party when you initiate this case, you don't have to then start contact, because it says that it has to be consistent with the habits of the family. So if the habits of the family were no contact to one parent, you can, it wouldn't be a violation of the automatic orders to continue the no contact provision. 4, neither party shall cause the children of the marriage or civil union to be removed from any medical, hospital, and dental insurance coverage, and each party shall maintain the existing medical, hospital, and dental insurance coverage in full force and effect. So, you can't remove the kids from your health insurance or dental insurance, basically, once the action is initiated. 5, the party shall participate in the parenting education program within 60 days of the return date or the complaint, or within 60 days from the filing of the application. So there's a parenting education program that everybody is required to take in Connecticut if there is a case that's initiated which involves children. So, this just says that you have to take it within 60 days of the return date. 6, these orders do not change or replace any existing court orders, including criminal, protective, and civil restraining orders. So, protective orders, restraining orders, those trump the automatic orders. This is just making that clear. In all cases involving a marriage or civil union, whether or not there are children. So this does not apply to custody cases, that involve children. It basically applies to all divorce or legal separation cases or annulment cases, which are less common, regardless of whether or not there are children. So 1, neither party shall sell, transfer, exchange, assign, remove, or in any way dispose of without the consent of the other party in writing or an order of a judicial authority any property except in the usual course of business or for customary and usual household expenses, or for reasonable attorney's fees in connection with this action. So basically, you can't hide any assets. You can't, transfer something into your mom's name. You can't, you can't do anything sketchy with your assets. Obviously, if you can carry on your life as you would normally. So it says except in the usual course of business. So if it's, if there's junk in your house that you would, that the other party doesn't want, and it's just stuff that you've been meaning to throw away, and it just happens to be that a divorce is initiated, you can still throw away that stuff because it's the usual course of business. But don't throw away your spouse's prized personal possessions. That will not be, it's a violation of the automatic orders, and it will not be looked favorably upon by the court. So they will not be a fan of that. Don't throw anything away. You want to preserve everything. There's an exception if you can sell assets if you need to pay for household expenses. So if your spouse leaves and is not giving you any financial support whatsoever, and you need to sell something in order to have money to pay your utilities or your mortgage or whatever, there is an exception that you can, dispose of property or sell property or whatever to cover usual household expenses. But again, don't be loosey-goosey with this, and I would consult, if you're working with an attorney, I would, talk to them about this, or, if you're not working with an attorney, call an attorney and talk to them. Because again, the court will not be happy if you just sell assets and say, oh, you needed to do it in order to cover household expenses, but you didn't really need to. So you have to be careful with that one. And then there's another exception that you can sell assets in order to cover reasonable attorney's fees. So, if you need to sell your motorcycle in order to pay the retainer for your divorce, you can do that. So long as you don't have money, sitting in a bank account. It's just, again, you can only sell things if you really need to in order to cover household expenses or to pay your attorney. Then there's a couple of subsections here. So nothing in, subsection 1, which we just reviewed, shall be construed to preclude a party from purchasing or selling securities in the usual course of the party's investment decisions, whether held in an individual or jointly held investment account, provided that the purchase or sale is one, intended to preserve the estate of the parties, two, transacted either on an open and public market or at an arm's length on a private market, and three, completed in such manner that the purchased securities or sale proceeds resulting from a sale remain subject to the provisions and exceptions recited in 1 in the account in which the securities or cash were maintained immediately prior to the transaction. Nothing contained in this subsection shall be construed to apply to a party's purchase or sale on a private market of an interest in an entity that conducts a business in which the party is or intends to become an active participant. So basically, like if you have a brokerage account and you want to, trade funds around, in a way that you normally would have in the past, you can sell stock and, you can make investment decisions that you would normally make, and again, if it's intended to preserve the estate of the party. So if it's a sound financial decision, just don't go doing anything radical with your, with your investments, because again, that could be looked poorly upon by the court. And then again, you don't buy into don't buy a business. That in this last sentence, precludes you from doing that. So subsection B, notwithstanding the requirement of 1A, that the transaction be made in the usual course of the party's investment decisions, if historically the party's usual course of investment decisions involves their discussion of proposed transactions with each other before they are made, but a sale proposed by one party is a matter of such urgency as to timing that the party proposing the sale has a good faith belief that the delay occasioned by such discussion will result in loss to the estate of the parties, then the party proposing the sale may proceed with the transaction without such prior discussion, but shall notify the other party of the transaction immediately upon its execution, provided that a sale permitted by this subparagraph B shall be subject to all other conditions and provisions of 1A, so long as the transaction is intended to preserve the estate of the parties. So again, if it's like an emergency sale that you need to make in order to, not lose a ton of money, you don't necessarily have to get the consent of the other party. You just have to let them know afterwards. So, these are somewhat like nuanced and niche things that won't apply to a lot of people. So, you probably want to talk to your attorney or a attorney if you're planning on and doing anything within these subsections. So then we go down here to neither party shall conceal any property. So don't, you want to disclose all of your assets. You cannot fail to disclose any assets that you have. 3, neither party shall encumber except for the filing of a lease pendants without the consent of the other party in writing or an order of a judicial authority any property except in the usual course of business or for customary and usual household expenses or for reasonable attorney's fees in connection with this matter. So you can't, take a mortgage out on your house or things like that unless you are doing so to free up money so that you can, it's to cover basic expenses in the usual course of business or for customary household expenses or for attorney's fees. 4, neither party shall cause any asset or portion thereof co-owned or held in joint name to become held in his or her name solely without the consent of the other party in writing or an order of the judicial authority. So if an asset is in both of your names, you can't do anything that would put it solely in your name while a divorce is pending or a divorce. 5, neither party shall incur unreasonable debts hereafter, including but not limited to further borrowing against any credit line secured by the family residence, further encumbrancing any assets, or unreasonably using credit cards or cash advances against credit cards. So you cannot take on unreasonable debt. It's similar to not being able to sell assets. You just can't do anything financially unreasonable. You have to kind of follow your normal, family traditions with money, basically. 6, neither party shall cause the other party to be removed from any medical, hospital, and dental insurance coverage, and each party shall maintain the existing medical, hospital, and dental insurance coverage in full force and effect. So before we talked about the fact that if there are children involved, you can't remove the children from any medical insurance. That also applies to, if there's a divorce pending and your spouse is on medical insurance, you can't get mad at them because they filed for divorce and remove them from the insurance. You have to keep them on the insurance. You have to keep the current insurance in place. And you cannot, it would be a violation of the automatic orders to fail to do so. 7, neither party shall change the beneficiaries of any existing life insurance policies, and each party shall maintain the existing life insurance, automobile insurance, homeowners or renters insurance policies in full force and effect. So again, you can't get pissed at your spouse and change the beneficiary on your life insurance or take them off the auto insurance or change the homeowners or renters insurance policies. You have to keep those things in place. Otherwise, it's a violation of the automatic orders. And if somebody violates the automatic orders, they can file a motion for contempt, bring you into court, and ask that you be held in contempt if you violated any of these automatic orders. 8, if the parties are living together on the date of service of these orders, neither party may deny the other party use of the current primary residence of the parties, whether it be owned or rented property without order of a judicial authority. This provision shall not apply if there's a prior contradictory order or of a judicial authority. So if you are living with your spouse and they serve you with divorce papers, you can't kick them out of the house. That would be a violation of the automatic orders. It's also a crime to, it's a criminal violation. You can be arrested for criminal lockout if you do that. So you need to make sure that you allow them to remain in the house unless there is a order to the contrary. And again, in the context of a divorce, this only applies if the two of you are living together when the case is initiated. This does not apply, if you're living separately when the case is initiated, you don't have to then let them into your house. All right, and then in all cases, so this is not limited to cases with children or, divorce cases or legal separation. This is all cases. The parties shall each complete and exchange sworn financial statements substantially in accordance with the form prescribed by the chief court administrator within 30 days of the return date. The parties may thereafter enter and submit to the court the stipulated interim order allocating income and expenses, including, if applicable, proposed orders in accordance with the Uniform Child Support Guidelines. So this second part is a may thereafter, so you don't have to do that. But the first part is basically saying that within 30 days following the return date, you have to exchange financial affidavits. And I have a separate video that talks about, financial affidavits and how to fill them out. And then 2, I don't know why this is still on here because case management dates aren't really a thing anymore. So it just says the case management date for this case is blank. Parties shall comply with section 25-50 to determine if their actual presence at the court is required on that date. So we now have resolution plan dates. We don't even have case management dates anymore. So those are the basics of the automatic orders, which again are in effect while a custody, divorce, legal separation, annulment case is in effect. And you just need to make sure you follow these orders because a failure to do so could, you could be held in contempt by the court for failing to follow court orders. So as usual, if you have any other questions or if you have any questions about this document, I'd invite you to contact our office. And if you are looking for representation in a divorce or custody or other family law case, we would invite you to contact our office as well.